Obvious to me. I admit that we didn't find somebody to come in here and testify, that he picked up the phone and said, ignore Judge Slobel's orders. It doesn't have to do that. I think that the auditor attempted, at least Wednesday, starting to use advice of counsel as a defense. Because there was testimony from the witness stand that even Attorney General Jim Hood was involved in the deliberative process about what to do in complying with the federal grand jury subpoena and complying with Your Honor's orders and opinions. And it was Mr. Huggins who testified, I think, well, Mr. Huggins testified that in discussions with someone at the Attorney General's office, he said either Jim Hood or Mr. Langford, told him that the federal grand jury subpoena trumped this court's orders and opinions. It's a knowing, contumacious, willing violation, not merely avoidance, it's a violation. Whoever gave that advice and whoever acted on that advice knew he was violating this court's orders.
They do their job, and they follow the instructions of the Assistant United States Attorney who was in charge and who led this investigation. And there is no person at the Department of Audit who had any intention, willful, contumacious conduct, or anything else from the time this public records hearing took place on October 30 and the court's conference on October 31. There is no one who had any intention of doing anything but honoring the fact that this court had ruled that those were public records. State Auditor, the Mississippi Department of Audit do not deserve to be held in contempt of court. We think they have acted in every way in a manner that should bring respect to them as law enforcement in the state of Mississippi. And we ask the court to consider that when it deliberates its decision.
There's been no testimony or proof that the records could have been copied after the time that Mr. Huggins was served with his subpoena. As he testified, he was under the impression that up until somewhere around 2:30 in the afternoon, that it would be sufficient for him to have the records sealed in place where they were on the Gulf Coast, and that he would appear the next day.
Having said that, should Judge Sterritt rule against the auditor in this situation, then I suppose these proceedings in front of this Chancery Court would be completed and the court could finalize its judgment and move on from there. Should the auditor prevail in federal court and the documents are returned, how the auditor handles the situation from that point then must be considered as a part of these contempt proceedings. And so they can't really be completed until we have that ruling, and the court then can take into consideration the actions that the auditor takes once it receives that ruling. And so I can't rule. And I will be considering all of these matters and whatever matters from here on out. And then you will receive my ruling in writing as soon as I'm able. Okay? You may then provide your additional evidence. You said on attorney's fees, and of course you have time to object, and I think there's plenty of time for all of that given time frame. All right. Is there anything else?
Nothing, Your Honor.
Thank you.